It's time for FLALAW, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Thanks for tuning in, folks. This is your live legal call-in talk show, and we come to you every Tuesday at 5 o'clock to answer your questions live on the air. Thank you for joining us. Hopefully you are a faithful listener and you know that we have been doing this for quite some time now. And so this is your cue to call your family members, friends, share, let people know that the show is on the air. It's 5 o'clock and it's that time for them to be able to tune in. Not only get some good legal information for the next hour in regards to personal injury and different things that might be emerging in our local area and the legal news front, but also it's their opportunity to call in with their legal questions in regards to things that they might be dealing with, questions about, and they haven't had a chance to speak with an attorney. Well, tonight's their chance. So hopefully you can share this broadcast. We, of course, are right now in the studio at WTAN. 106.1 FM and AM 1340. We're also streaming live right now. So if someone is outside of the broadcast network, but they still want to tune into the show, no worries, not a problem. They can absolutely do that through not only Facebook, but also YouTube. So I'm going to tell you how to find those broadcasts so that you're able to share it with friends. We would love for you to share it out, get people to tune in right now and be able to ask their questions. It can be found at our firm page at Perenich, Caulfield, Avril Noyes Injury Lawyers. If you type that name into either Facebook or YouTube, you should be able to find the live feed right now. We are in the studio, and you can comment in the comment section in either of those live feeds, and we'll get those questions and we'll read them out over the air. Or even better, you can call into the studio. The number is 727-441-3000. Again, that's 727-441-3000. And that will be the best number for you to call in for the next hour and get your questions answered live over the air. So that's obviously preferred. I would love to hear from you, hear your voice, have a conversation with you. But that's okay. If you don't want to have your voice on the air and you just want to drop a quick question in the comment section, then Facebook and YouTube is the best way to do that. And again, we'll be checking those out throughout the show tonight and reading them out over the air. If you're not able to finish watching the show live, but you'd like to catch up with it later, no worries. That is, there's so many ways that you can do that. One of them is our podcast. So we do have a podcast where these shows will go up on our podcast after the show, and they'll be there with multiple other shows for, every week. We put those up there so you can go back and listen to last week, the week before that, and last month as well, so that you can catch up on all the legal shows that have been on FLALAW on the radio. So if you do consume your podcast, let's say Spotify or iHeartRadio, Apple Podcasts, whatever it is, you can find us that way, because all you have to do is type in FLALAW on the radio. You will find the podcast there. You'll find all of our past shows as well. You can tune in, listen. You can obviously listen to the podcast on your commute, on a long ride home, or at the gym, whatever you do when you consume your podcast. This is a great show for that. You get lots of fun information and different topics from different legal minds in the community. We've had all kinds of attorneys, bankruptcy, family law, tax, you name it. And so tonight, obviously, you got some great personal injury information coming your way. We are the attorneys at Perenich, Caulfield, Avril Noyes who do host the show. So a lot of our information comes from that lens as far as civil litigation and personal injury matters, car accidents, slip and falls, wrongful death, medical malpractice. Those are the kinds of cases that we handle, and those are a lot of the topics that we do touch on for night to night when we're here on Tuesday evenings. And so if that's your thing, if you're interested in that, you have dealt with something like that in the past, or if it just is a topic that you are interested in, then of course, continue to tune in and let folks know, share the broadcast, comment, like it, so that we can get some more engagement going and, of course, grow our viewership. With that being said, we're going to build on last week's show. We did a little bit of a behind the scenes, if you will, of what goes on really in personal injury claims and lawsuits, and we hadn't got quite up to trial or the things that can happen right before trial. We had kind of gotten through, we talked about deposition, discovery, and mediation, and then we kind of stopped there and our show ended. But obviously there's more to that. If the case doesn't resolve at mediation, then you have questions about what happens next. So that's going to be a good portion of tonight's conversation. But before we get into that, I like to always try to start the show out with some current events whenever I can. If there's something pressing going on in the news or interesting that kind of ties into what we do, I do tend to try to talk about that just because I know folks are either seeing it or listening to it or hearing about it like I am. Because if I'm hearing about it, then I would imagine most of our listeners are starting to hear about those things too. And so I tend to try to see if we can tie it into our show and give people good information when it comes to that. And the ironic thing about it is we kind of talked about it a little bit not too long ago, a couple shows ago. There was a listener who had a question about golf carts. And then in our golf cart conversation, we started talking about e-bikes and e-scooters. And so I don't know if you're like me, but you've been seeing some e-bike information and things going on in the news because e-bike accidents are becoming really, really prevalent. Like they're happening a lot. And sometimes the bicyclists on the e-bikes are the ones that are at fault. Because those things, they just move so quickly. And sadly, a lot of people that are using these bikes are not necessarily taking the most safety precautions when they're riding them, and they're traveling a lot faster than a traditional bicycle would travel. And they're not necessarily as alert in obeying all the traffic laws. And when that perfect storm of things, combine, it results in a lot more accidents. And sadly, it's young people too, because as you can imagine, there's teenagers and young people who are taking these e-bikes to school and they're just driving really fast. And a lot of them aren't wearing helmets. And so I've been seeing a lot about these e-bikes lately, not even just in the news, but even in my own practice. We've seen a lot of these starting to come through the door. And so I was getting ready for work this morning and I saw it on Bay News 9. They were talking about a specific community in Hillsborough and Fishhawk, where parents are trying to get a petition going to maybe better regulate these e-bikes in their area. And so before I jump into that, I wanted to just talk a little bit about the statistics when it comes to e-bike accidents. So according to some research I did online, it says that e-bike accidents and injuries are increasing significantly across the country, with hospitalizations for e-bike injuries rising from a few thousand in 2017 to now over 24,000 in the past 2 years. So injuries in these cases, unfortunately, are a lot more severe than what you might, encounter in a car accident or something of that nature, because obviously their body is making direct contact with either the ground or another vehicle. And so these injuries often involve fractures, lacerations, head trauma, because of, the urban street surfaces, and the riders are sadly less likely to be wearing helmets. And so that is, of course, causing a lot more injuries. Let's see if we have some hospital statistics. It looks like it has increased. Hospitalizations as a result of e-bike accidents has increased by 43 times. Fatalities, it looks like that has increased, it looks like by 6 times. So it is going up exponentially. And the most common injuries being lacerations, fractures, and concussions. And that's pretty much comparable. And what I've been seeing in my own practice is the kind of injuries that are coming through the door when folks are having these e-bike accidents. A lot of them are involving head injuries, broken bones, pretty severe lacerations, abrasions, things of that nature. And so these are not things that you want to take lightly as far as taking the proper safety precautions when you're on these kinds of bicycles. And so going back to the news, obviously that's the reason why we're talking about it, is because it's been in the news. I saw recently, I think St. Pete Police had posted some safety advice when it comes to these e-bikes. And then this morning, I saw the story that was being broadcast on Bay News 9 about the parents in Fishhawk who want more education and regulation for e-bikes. So what's going on over there is some of the residents in Fishhawk, which is kind of in the Brandon, Hillsborough County area, they're saying that they're seeing more kids and teens on these e-bikes than ever before, and many of them aren't riding them responsibly. They're kind of being wild and reckless with it, not wearing helmets. And so one mom is taking it upon herself to start this petition in her neighborhood for e-bike education for students, because she's a nurse and she's really concerned that someone's not only going to get seriously injured, but potentially could lose their life because they're not taking the proper safety precautions on these e-bikes or e-scooters. So she's basically looking for more regulation and safety for those types of e-bikes and e-scooters. Apparently, she said in the past, she's seen about a dozen kids that are typically coming out of the middle school near her home, which is Randall Middle School. And they're moving really fast and they're not paying attention. And one of the parents said it's almost like there's no fear in these children. They almost think they're invincible. And it's pretty scary as a parent. So she started this petition for first responders to implement an e-bike education in Hillsborough County schools. As a parent, she thinks that doing nothing is not the answer. And obviously there has to be something done about these e-bikes. She noticed that there was a lot of accidents happening lately with the e-bikes and there's no regulation. In Hillsborough County, you do not, and it's the same in Pinellas, so you do not need a driver's license or registration for these e-bikes for class 3, which can go up to 28 miles an hour. The sheriff's office, I couldn't hear you. What'd you say, Ed?
I was just going to say they're more than that, because I have been on my motorcycle and they keep up with me at 35, 38 miles an hour.
Dude, absolutely. Absolutely. So I don't know. I mean, this could be a rough estimation, but I've definitely seen e-bikes that go way faster than 28 miles per hour. That's for sure.
And you're giving them to kids that are 12, 13.
Mm-hmm.
Used to be in the old days, you couldn't own a motorcycle if you were under 16 and ride the roads.
Right.
And these things are sharing the roads with cars.
And they're zooming. And the problem is a lot of them are not wearing helmets, exactly like she said. And there's really no real requirement for helmets. If you're, it looks like it says sheriff's office says riders age 16 and under are required to. So over 16, they're not required to have a helmet on. And that's exactly why we're seeing so many like serious head injuries and things of that nature because of these. So for e-bikes and motor scooters, you do have to obey the same laws as drivers on the road. You cannot drive the wrong way on the road, which we see a lot. You do have to obey the stop signs, traffic lights, the same way you would as an ordinary bicyclist or pedestrian. And so I just think people are poorly educated when it comes to this, and especially the younger kids, like the middle school age and, the younger high school kids. They're just not really aware and they're driving them pretty recklessly. So according to the sheriff's department in Hillsborough, I think they're obviously receptive to it. They're trying to work on some sort of educational program for that county. And so, hopefully that will come to pass. According to Tampa General Hospital, they're seeing more injuries as well at the age group of riders. Muma Children's Hospital, I'm not familiar with where that's located, but reports there that there's an e-bike injury surge with pediatric cases in Florida up 500%. Oh my God. And then of course the most effective age, it being the ages between 12 and 15. So that's pretty consistent with what I've been seeing too, as the age group that's out there kind of being the offenders, and they're having the most serious trauma. So, I'm sure more of this is going on in different communities, but I just happened to see that story this morning on Bay News 9 with the e-bikes. And I said that, that's exactly consistent with what I've been seeing as well. And so, we mentioned it before when we were talking about these golf carts as well. And so there's not like you have to carry insurance with these bikes or scooters. And so that it's not something where if you get hit by someone, because a lot of times these e-bike riders are the ones that are at fault, and they could run into you and run into your car and cause a pretty serious accident, but they're not obviously going to be required to carry any type of auto insurance under Florida law. And so that creates issues. And fortunately, though, for the e-bike riders, I have been seeing Florida PIP coverage, which is the PIP, no fault benefit. It has been covering these e-bikes, even though there's a gray area there because it's like a motorized scooter. And technically, under Florida law, the motorized vehicles can become tricky when it comes to whether or not they're going to allow you to have that coverage. Motorcycles don't get the PIP coverage. And so you've got these two-wheeled bicycles, but they're e-bikes and they drive really fast. But right now I've been seeing PIP cover them just like regular standard bikes, where if you get hurt, you still get that $10,000 in medical benefits, regardless of whoever's at fault. Even if the e-bike rider is the one that caused the accident, they still could get that $10,000 in medical coverage that would go towards, an ambulance visit, ER visit, follow-ups, MRIs, things like that, up to $10,000. Which I guess is one benefit. It doesn't mean that every insurance company is going to approve it. Some of them might fight it because of, number one, it's a two-wheeled motorized vehicle that does go quite fast, and it's electric, and it's not a standard bicycle. But like I said, here lately, I've been seeing them go ahead and afford that coverage, even though it's an e-bike. That's not always going to be the case for every type of motorized apparatus or scooter. Mopeds, motorcycles, things like that are not covered usually under PIP. And so you would have to use your own health insurance and things like that. You wouldn't necessarily get that $10,000 in PIP.
But mopeds, motorcycles, you have to be a certain age
Absolutely.
to drive. So let me ask you, you're pulling out of the grocery store and some kid under 16 on an e-bike flying down the road and hits you broadside at 35. Hopefully the kid's okay.
Yeah.
And the kid is at fault. Can the parents be held liable?
Yeah, potentially, but there's different theories of liability. So, it just depends on the circumstances. Obviously, if it's being truly negligent and there's nothing intentional about it in terms of how it all happened, then there could be a theory of liability of like negligent supervision of the child. You might even potentially be able to look at the parents' policies, but you are likely going to get some pushback from the carrier because of the apparatus, that device that they're on. And so it's not a vehicle that's insured under the policy.
And they're not regulated.
Yeah, right. So the chances are they're going to say, well, this isn't something that's insured under our policy, and they're not a driver under our policy. This is a child in their household that's probably not even listed in the insurance. And so you're likely going to have some big issues in trying to prove that claim. Now, potentially, I'm thinking more homeowners insurance lines there. Maybe there could be an avenue with that where the vehicle is not necessarily a motor vehicle. So it just depends on how you present it. So, if you present it like an auto accident and it's an auto case, then likely you're going to hit some denials and some insurance issues under the auto. However, maybe a negligent supervision under the homeowner's policy, potentially, so there's things that could be looked into, but you're going to definitely have to do some digging and some fighting when it comes to that. And so, you definitely got to call, us, personal injury attorney, to try to parse through that and figure out what type of claim could be made. But that's what I fear is going to be happening, where you have these big injuries that can come out of something like that, or even big property damage. They could, total your car, and like, who's responsible, And so that's why I always tell people, because you don't quite know how these things are going to play out with golf carts and e-bikes and these e-scooters, you just got to protect yourself. You have to have, good coverage, like collision coverage, comprehensive, uninsured motorist coverage, because again, you're just not sure how these things are going to play out, because again, no requirement for them to carry it, no requirement for them to have any type of bodily injury coverage or comply with Florida insurance laws whatsoever. So that is going to be obviously something I think we'll see a lot more of, because they're just not covered like cars, and they can still do a lot of damage though, just like a car. I'm not going to get back into the whole golf cart argument, but it's very similar. We talked about that before. The only caveat for those that may have not catched the other show about the golf carts, some golf carts are registered. And so that means they have a Florida license plates, their VIN number is registered with the state of Florida. Those kinds of vehicles are different in a sense that they are required to comply with Florida insurance laws. So don't assume that we're making a blanket statement about all golf carts, all e-bikes, all, e-scooters. Golf carts are slightly different in the sense that some of them are registered and some of them do have those license plates. So that's kind of the distinction. If you find yourself in a scenario like Ed was talking about, where someone, comes out of nowhere and they're on a golf cart or whatnot, look to see if they have a license plate, because if they do, then there might actually be some coverage there, and you could potentially still be in luck if you end up being injured by someone like that. That way you don't necessarily have to stress or fret as much. But if they are one of these golf carts that don't have a tag, they're not registered, then you could be in one of those situations that you don't want to be in, which I go back to my soapbox. We do it all the time. Carry as much as you can afford. We know that people will tend to cut the on their policy, because that's what makes the policy price, tend to increase. You can kind of play around with it sometimes and figure out what coverages and limits are going to cause your premiums to be at a rate that you want or don't want. And when you add the it does increase it. But at the end of the day, that's the kind of coverage that you don't want to end up in a situation where you need it and don't have it, because that could be the difference between you being fairly compensated for an injury, for having serious, wage loss, lifelong permanent injuries, back injuries, surgeries, things that are piling up in terms of bills. And the person that caused the accident may not have coverage or may not have adequate coverage. And we're seeing it a lot more here, obviously, in days where, the economy isn't all that great. People are trying to save money here and there. And the first thing they do is they'll cut down their limits on their insurance policies and think, hey, I'll save a few bucks there. And it's to your own detriment, because now you're exposed, because there's so many drivers out there on the road who just don't have adequate coverage, or they're not carrying any coverage at all. That's a whole nother conversation. And you have to know how to protect yourself when it comes to that. So that's my speech about the e-bikes. They're very much becoming an issue. You have to you just got to be really defensive when driving around these days, especially when you're in those areas where schools are at, those neighborhoods where there's lots of kids that are just riding around with these downtown areas. You just got to be really vigilant, because they're becoming more prevalent. The injuries are serious and they're not insured, right? So with that being said, I think that's a good place to take a short break, and then we'll jump back into going behind the scenes with personal injury cases. We'll be back after this break.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
And we're back. Thank you for tuning in. This is FLALAW live on the radio. Hopefully you have been listening since 5. We have been going into the topic of e-bikes, but now we're going to get back into something we started talking about last week, which was basically taking a peek behind the curtain, a little bit behind the scenes of what really goes on in personal injury cases and getting into those facts so that people have a better understanding. So I think a lot of times there's a misperception of what really goes on. You see these, TV shows or commercials and billboards, and you think you have it all together. That was one of the biggest wake-up calls, I think, when I went to law school and I started learning about the rules of evidence and, trials and how to try cases. And I realized that the TV shows and movies are so off. They're so way off as to how they really portray what's going on in courtrooms, to the fact that I just stopped watching a lot of them because I'm like, oh my gosh, that's not accurate. That does not comply with the rules of evidence. That would never come in. You would never hear about that. I was trying to remember, there was a show that I was watching the other day and I was just completely annoyed because there was a situation in the trial where the defendant was trying to keep certain evidence out, and they were basically arguing a motion in limine, and they basically argued the entire thing in front of the jury. And the judge was like, okay, I'm going to rule that it not come in. And it's like, well, the jury just heard every single thing. And now you can't unring that bell. Like, it was like, okay, they just absolutely heard everything you didn't want them to hear. Why would you say that and argue that in front of the jury? And it was like an open court. It wasn't even like a sidebar where they said, oh, Judge, may we approach the bench? It was just completely argued in open court in front of the jury. And then the judge instructed them to disregard it. But it's like, Judge, you can't disregard it. They've already heard it all. But anyway, it's that kind of thing where it's like little stuff that people might assume or think, oh, you can do this or that, and it's appropriate just because they've seen it or heard it in whether it's TV shows or there's so many good series out there. There are some really good ones that are I would say a little bit more accurate than others. I think The Lincoln Lawyer isn't terrible. They do bend the rules of evidence quite a bit, and the rules of ethics. Not terrible. Well, there's some ones out there that are decent in terms of you can tell they actually have real trial lawyers who are helping with the writing of the show, as opposed to some of these shows where it's like, did anybody that actually went to law school help you guys with this? But just to go back over what we had touched on a little bit last week, obviously, there are a lot of parts, and steps that are going to lead you up to the courtroom, the courthouse doors. You don't just, I mentioned it last week, you don't just jump straight to a lawsuit. You're not going straight to court as soon as you get injured and the lawsuit gets filed. Not to say that you can't. Now, you absolutely can, and sometimes it's warranted, depends on the circumstances. To give an example, I think the boating accident that happened not that long ago that was in the news here with the ferry in Clearwater, where there was a fatality and there was lots of injuries where the boat ran into the Clearwater ferry. And there were some allegations of, there not being adequate lighting, and, maybe the person that was driving the boat couldn't see. And there were so many different factors, but there was a person that unfortunately died as a result of that. And then there was a lot of people that were injured. And I do remember in a case like that, those lawsuits are typically filed a lot sooner, and I don't think that there was a whole lot of delay when it came to those, that the lawsuits were filed fairly quickly. However, in most circumstances, that's not the case. You are going to have steps that lead up to, getting into the courtroom or going up to, your day in court or the day in trial. And a lot of that is discovery. There's discovery, there's depositions, there's motion practices, there's pretrial things that are leading up to the trial process. And now, as of lately, the courts here locally in Pinellas and Hillsborough and across the state are, based on the Florida Supreme Court rules, are having to set trial within an 18-month period. And so that means once the lawsuit is filed, typically speaking, you'll have a projected trial date that is 18 months out. So that would require the parties to be working together in that 18-month period to be moving things towards that projected trial date. Now, in actuality, you're typically not going to have a trial happen in that time frame, because a lot of times there's many other cases also set for trial on that same trial docket, whereas the oldest case usually is the one that ends up being called for trial. And so the one that is set and is only 18 months old will likely not be the one that's going to be tried on that date. It's typically the cases that have been in the system for longer, 24 months, 36 months, and can be very, even longer, because there's so many things that can go into trials depending on the circumstances and how many parties there are and the damages and the evidence. The discovery and the workup portion that we talked about can take a lot longer than 18 months. And so it's been a case that's still going through the system. And so if you're both on the same docket with an old case and then your newer case, then of course the older case is the one that's going to be called up for trial on that particular docket. And then your case gets bumped to another date. But the lawyers are obviously working up the case in that time frame, because what you don't want to happen as an attorney is that you're getting up to the trial date and you haven't done all the necessary things that are required under the law and usually by a case management procedure and order for you to do, and you haven't done it. So those are the things that are happening as you're getting closer to that day. And so we touched a little bit on it last week, where there's written discovery, there's depositions, and then there's the mediation. And those are the things that are kind of happening sometimes before the trial is even set. And then after that, let's say you've gone through the mediation process and you realize that this case is not getting settled, or the offers are just not coming together. We're nowhere near, reaching any kind of resolution. What happens next? Typically, if there's not already a date certain for trial or projected trial date, then your attorney may file what's called a motion for trial or motion for case management, so that it can be added to the trial calendar, because the efforts to try to amicably resolve things on your own have failed. We went through that mediation process that's required in the Sixth Circuit, and it did not result in a resolution. We reached what's called an impasse, or basically the parties couldn't agree. So the motion for trial is usually next. Then you will likely have a case management hearing that's set, where the parties will come together and try to figure out the logistics of how things will move forward, where there's going to be deadlines set. When will the discovery process end? At some point, the gathering of facts and information and talking to witnesses, that will end. And so usually it's, a couple weeks before the pretrial hearing. But those are the sort of things that the parties are working together to figure out. And then there's obviously expert discovery. So let's talk about that quickly. So the kinds of experts that can be brought in these kinds of cases can be doctors, the treating physicians, the doctors that are seeing the person that has been injured, the ones that were making the recommendations and performing surgeries, those sorts of things. The doctors are the experts. The billing persons, the ones that are working in the office but are handling the bills and the codes. Those potential individuals can become experts at your trial. The defense lawyer on the other side is also able to retain their own doctors, and the ones that can evaluate you and say the opposite or whatever than what your treating doctor is saying. Those are experts. The radiologists, the ones that read the films, the ones that are trying to determine what your MRIs show. Those radiologists, whether they're the reading radiologists or a hired radiologist, those are also experts. There's economists, there's life care planners. Those are people that are skilled in saying, what your losses and damages are going to be projected out over a period of time, and how that's going to add up over your lifetime as a result of the accident. So those are experts. So those are the kind of people that can be called in regards to doing discovery and preparing them and getting them ready for trial. And that can be very expensive. Usually that's the most expensive part of trial preparation, is working with the experts. And so when you reach an impasse, meaning you get to mediation, you guys all sit down, you can't get it settled. Those are the kinds of things and costs that you're trying to factor in as you prepare for trial, because at that point it's going to start getting very costly, because these experts that are doctors do not come cheap. They're quite expensive, and they do come with hourly fees and retainers and things of that nature, and their fee schedules are quite pricey. And so if you want these people to come to trial and testify on your behalf, you have to pay what their fee schedules are. And that is where the cost of going to trial can then become very expensive. And sometimes it depends on the circumstances. It can become cost prohibitive. It just depends on the case. But that's what's happening in the lead up. So now that mediation is ended, you didn't get anywhere with that. Now we're doing the case management. We're figuring out our deadlines. We're making sure we're talking to our experts, and we're getting our experts together and their witness testimony. Also, sometimes the experts can be, engineers and different specialties that could help with liability disputes. Sometimes accidents turn into he said, she said, or, I had the right of way, this person didn't, or I had a red light and that person had a green light, or whatever the circumstances are. Or I turned right and they turned left. And so you need people to come in to reconstruct that at times and be able to say how it all happened and what's the most plausible explanation for it. By the greater weight of the evidence, you're trying to figure out how did it all occur. And so sometimes those are the kind of experts that you need as well. It's not always just the treating doctors and things of that nature. So I wanted to make sure I made that clear. Experts can be a wide range of individuals as far as, depending on what you need to prove at trial. And the person that got injured is the one that has the burden. The burden rests with the plaintiff, the one that's bringing the case. And so you have to prove your case. And that could mean bringing in the right experts to do that. And so with that being said, these are the things that are going into the buildup of, preparing the case and getting it ready before you even get to the courthouse, right? And you better believe the defense is doing the same thing. And they may have been doing that from the beginning, which is hiring their own experts, having someone, review your records. I just talked about this with the client as well, about how, they're going to do the same thing that we're doing, but to prove their affirmative defenses or what their theory of the case is. So that means they're going to take your records and give them to one of their doctors and have their doctors review the records and have their doctor evaluate you with what's called a compulsory medical examination, where you have to go and visit their doctor one time. That doctor looks you over, barely touches you, doesn't spend a lot of time with you. And then they'll reach this 3 or 4 page opinion about you and say, but these are all the reasons why you have the pain that you have, and it has nothing to do with the injury, or if it did have something to do with the injury, it should have been better by now. And so anything that you feel now is not because of that, and or for various reasons, they'll have come up with. They'll say it's arthritis, or that it's a pre-existing thing, or you had some other car accident or some other fall or some other injury that this is from, and not because of this current present thing. And so that's their job. So they will hire the same kinds of experts. They'll hire, the same specialists. They'll hire radiologists, and they'll hire, counter experts to what your doctors or what your experts have to say. And so they're absolutely doing that. And they're also doing other things behind the scenes, like getting surveillance on you. They're sending out, investigators, and they are potentially watching you. It doesn't happen in every case. So I know a lot of clients will ask me about that. It doesn't always happen. So I don't want to give the impression that this is an all the time thing. You can get through a beginning and end of a personal injury case and no one ever watches you or surveils you, but it does happen. And especially once you get into litigation or getting, towards trial. And so they'll try to see what you're doing, and they'll watch you at work, and they'll watch you when you're playing with your children. They'll watch you when you're at the gym. They'll follow you on vacation. I remember watching surveillance video for hours when I was a law clerk for a major insurance company in their trial division. And I was given a stack of CDs with hours and hours and hours of surveillance footage that I had to watch. And I was watching a plaintiff go on vacation with his family, and the investigator literally followed him up to Georgia to some water park, and watched him get on the inner tubes with his kids. I mean, they don't have any shame. They're literally will watch you for hours, and they're getting paid for it, so why not? And so they sift through this footage, and they will look for anything that they can find to somehow suggest that you're okay and you're fine, and the injuries that you say you have, you don't really have, because look at this footage when you were with your family. You were doing all those things, and you must be okay. And so that's what the defense lawyers are doing. They're getting their experts. They're doing surveillance. They're subpoenaing your records from 10 years ago, from other accidents that you've had, for doctors that you've seen, doctors that you might have even forgotten about. Depending on how far back they can find, they'll go back as far as they can. And a lot of times the records just aren't able to be located because of how long ago it was. But sometimes medical providers keep records for quite a long time. And so they may have records spanning back years and years and years. And that's what they're doing. They're sifting through that. They're getting that ready for trial. They're looking to find these things that are going to be evidence that they can pull up and show to a jury throughout the trial, and be able to point to various things and point them out to your own doctors and say, well, doctor, did you know about this? And doctor, did you see that in his history? Or did you see that in her medical history? And did you know about this thing? And if you had known that, would you still have the same opinion that you have about them today? And so those are the kinds of things that defense lawyers are preparing, and they're getting ready in terms of, their trial prep as we're moving closer towards the trial date. And so there's always things to kind of be mindful. I know a lot of clients will ask, well, is it at any point as we're getting ready for trial and we're putting all this time, expense, and effort into the experts, can the case still settle, or are we pretty much full speed ahead towards trial? The answer to that question is yes. So just because you are ramping up and you're getting ready and you're preparing does not mean that at any point the parties can't get on the phone together. The lawyers can always pick up the phone and say, based on this circumstance, based on this issue, based on what we now know, here's a new offer, or here's a new demand, or they could even be more formal and file something that's called a proposal for settlement. That gets filed with the court. We probably talked about that on the show before. It's basically like a tool that can be used to basically try to meet or beat. Well, I wouldn't say meet or beat, to try to beat at trial. So you file it for a number that's reasonable enough that you are willing to accept it if they pay it, but also something that you think you can actually exceed if you take the case to trial. And that's really the only way that proposal for settlement really has teeth that actually make it work, is if it's beatable. If you file it for a number that's extremely high and kind of outside of the realm of what may potentially happen at trial with a jury, then it doesn't really have any teeth. It doesn't have any bite to it. So if you file it for a number that's beatable and a number that actually you would actually want to accept, then it has teeth now, because what could happen is if you file that proposal for settlement and the case still doesn't settle, they still opt not to accept it, or the case just, they just blow it off and they don't accept your proposal for settlement. What happens now? You take it all the way to trial. If you get to a trial and a jury awards you 25% more than what you had filed that last proposal for settlement for, now, not only do you get whatever the jury awarded you, you also get all your attorney's fees and costs paid by the other side. That's what creates the teeth. That's what makes it sting. So you can get really strategic with something like that. That can be something that becomes helpful down the line, depending on how you use it and how the tool is used and at what stage it's used. The earlier on that it's used, sometimes the more effective it can be, depending on what you file it for. Like I've said in the past, if you file it for a number that's completely crazy, just out of the stratosphere, just not something that will ever happen, then it really doesn't really have any teeth at that point. So something that you always want to remember too, as you're getting close to trial, you want to be very mindful of the things that you're posting on social media, things that you're putting out in the world, in this, content crazy world nowadays. Everybody's a content creator, everybody's vlogging. Those things can always come back to bite you. Every post that you've made, every video that you've created. Again, these defense lawyers are looking for these things. They're watching and they are trying to build their defense for this picture that they're going to paint for you when you get to trial. And just very quickly in the last, few minutes, trials are, separated into various different parts. So there's picking of a jury, and some people would argue that that's one of the most important parts of the trial right there. That's it. The picking of the jury and deciding who's on your jury can be the end of the entire case. If you get a good jury, that could mean a good verdict. If you get a bad jury, that could mean you get a bad verdict. And so it just depends on, and it's an art, I will say, an art that I don't believe I've mastered yet. That's something that just takes time and experience and persisting. And a lot of it has to do with just understanding human nature, body language, and the responses, and understanding how to draw out of people the things that they have as far as their own personal opinions and biases, because people aren't always going to tell you that they don't think that you should have any money because you got hurt. They think that you're faking it or whatever. People have these biases and they won't always say that, or they won't always tell you that they had a mother who was badly injured in a car accident, and they're completely sympathetic to people that have gotten hurt, and they want everybody to get lots of money, and they don't always say that. And so it's your job as the lawyer to try to understand who has what biases and who's going to be helpful, who's going to be good for you, who's going to be helpful for you, and kind of building that together. And so breaking down the components of a trial, picking a jury. After you pick the jury's sworn in, then you're dealing with some housekeeping matters. There's arguing of motions and pretrial things like motions in limine, and that involves keeping evidence in or what comes in or out. Then we talk about opening statements. So most people understand what that is, and you see those in courtroom shows where that's where everybody first gets introduced to the case. What is this about? Who are we talking about? Who is the plaintiff? What are the issues? Who did what? Who are the main players? you're telling a story and you're explaining the story from the perspective of your own client. Both parties get their opportunity to do that. So you'll always hear from the plaintiff first, then you'll hear from the defense, and they'll tell their story and they'll give their version of what this is all about. Then the plaintiff has their case. That's basically called their case in chief. They get the opportunity to put on the witnesses, put on the experts, bring on the people, the family members, the friends, the ones that know this person the best and know how they've been impacted. And the plaintiff themselves, they get up there and they tell about their life and how this injury has impacted them. Once you get through all the witnesses and the experts and basically pulling out all the evidence you need from all those witnesses, then the plaintiff's case will rest. Once the plaintiff rests their case, there might be motions that are argued in between that time, between the defense lawyer might say that, oh, they didn't prove this or that, and the judge can rule on those things. And then depending on how those rulings go, then the defense lawyer has their chance. Now they have what's called the defense case in chief. They can put in their witnesses. Now they get to bring on their experts. Now they get to bring in, whoever they feel should be called as witnesses to present their case. And mind you, there's the direct examination, there's a cross-examination. So both sides get to bring, talk to their witnesses. Once all those witnesses and the evidence is collected, both sides have rested, then there's the closing arguments. And that's a little bit different from opening statements in the sense that it's not necessarily just telling a story. Now you get to argue your points. You re-argue everything that came out during trial. And you're going to basically hammer in the evidence that came forward. This is what was said. This is what they showed you. This is what they didn't show you. This is what you learned. This is what this witness told you. This witness is credible because of this thing. And this is what we know about this witness expert who is biased for whatever reason. And you make the arguments and you bring it all together and you tie it into your theme. Both sides get their chance to do that. The plaintiff gets a rebuttal, and then it goes into a jury. And at that point, it's in the hands of the jury. And the jury then gets to decide the fate of the person that has been injured. And they can take as much time or as little time as they need to go through the facts, go through the evidence. And then you hear that knock on the door. The jury has reached a verdict. They come out. And they either do something for you or something to you, depending on how you look at it. And so that's always very, very nerve-wracking, that moment of waiting for the jury to come back. You're sitting there on pins and needles, just, trying to figure out how this is all going to go and whether you laid your points and whether they understood the story and it all resonated. So hopefully you learned something about trials and you had a good peek behind the scenes. It was a good build on last week's show. And so between last week and this week, you should know how to try a case and you can all become lawyers now that I've kind of given you the whole spiel. So hopefully you learned a lot, and we'll be back next week with another great show. My partner, Matthew Noyes, will be here giving you some more legal advice with his special guests. So keep tuning in every Tuesday at 5 p.m. This is FLA Law live on the radio. Have a good night, folks.